Please take your seats. The meeting is about to begin. Remember to speak into the microphone, as this meeting is being recorded for public record. Please stand by. We are going on air in 5, 4, 3, 2, 1.
Okay, good morning. Welcome to the April 8th Planning Board meeting. We have a full attendance today, and the first thing I'll ask the board to do is approve the minutes from the last meeting. If I could get a motion to approve.
Motion to approve.
Okay.
Second.
Okay, all in favor? Aye. Anyone opposed? Okay, thank you. Nick?
Good morning, Mr. Chairman and members of the board. Today's meeting of the Planning Board will be conducted in a hybrid format, with the board physically present in the commission chambers at Miami Beach City Hall, and applicants, staff, and members of the public appearing either in person or virtually via Zoom. To participate virtually, the public may dial 1-877-853-5257 and enter the webinar ID, which is 861-4342-6327#, or log into the Zoom app and enter the webinar ID, which again is 861-4342-6327. Anyone wishing to speak on an item must click the raise hand icon in the Zoom app or dial *9 if you are participating by phone. If you're appearing on behalf of a business, a corporation, or another person, you need to register as a lobbyist with the city clerk's office. If you haven't registered yet, you should register before you speak to the board. You don't have to register as a lobbyist if you're speaking only on behalf of yourself and not any other party, or if you're testifying as an expert witness providing only scientific, technical, or other specialized information or testimony in this public meeting, or if you're appearing as a representative of a neighborhood association without any compensation or reimbursement for your appearance, to express support of or opposition to any item. Expert witnesses and representatives of neighborhood associations shall, prior to appearing, disclose in writing to the city clerk their name, address, and the principal on whose behalf they're communicating. If you're an architect, attorney, or employee representing an applicant or an objector, you must register as a lobbyist. These rules apply whether you're appearing in favor of or against an item, or encouraging or arguing against its passage, defeat, modification, or continuance. Lastly, I'd like to swear in any members of the public or staff who will be testifying today. Please raise your right hands. Do you swear or affirm that the testimony you'll give in this proceeding is the truth, the whole truth, and nothing but the truth? I do. Thank you.
All righty. We'll start with requests for continuance and withdrawals, which are several. And Michael, I know that some of the boards like to know what the reasons for it. So, and then you'll let me know if we need to vote on it. The first is Planning Board File PB 240656, 1235 Washington Avenue Nightclub.
Yeah, so this application, the applicant has actually withdrawn it, so the board does not need to take any action at this time on that application.
Okay. The next one, Planning Board File 220539, 660 Washington Avenue, the Anglers Hotel.
In this case, the applicant is requesting a continuance to the May 6th meeting. This was last advertised for the February meeting. The code places a limit in terms of the time frame, the maximum time frame of which an application may be continued. May 6th is the last date that the application could be continued to, unless the applicant provides plans at the time. So at this point, the applicant's requesting a continuance to the May 6th meeting.
Nikki?
Attorney for the Anglers. We've been here a couple times because of some other outdoor entertainment venues that have been more problematic. We've had, this process started a little before all those, but we've been working with neighbors that could be impacted to modify things, modify speaker locations. We were hoping to actually continue to July because we needed more time to update the plan and test it and everything else. But in speaking to Michael the last couple of days, because of the notice procedures, we can only continue it to May. And then we will be, at that point, probably submitting updated drawings and then ask you for, a little more time at that point. We would ask you for more time today, but we just can't because of the timing of the process. So we're asking for just May, but we still think we need a little more time to finalize things and make it right.
Is the proposed operator still the guy that has the Greek restaurant?
As for the, for the food and beverage, yes.
Yeah, okay. All right.
So we should take, see if there's any public comment
Yeah, I
on
was
the
going to
request for
ask.
continuance.
I'm assuming nobody in here is here to speak on this item. Anyone on Zoom?
There's nobody on Zoom with their hand raised.
Close the hearing. Any questions from the board? All right, all in favor?
We need a motion first.
Motion to approve.
Second it.
Okay, all in favor? Anyone opposed? All right, and what happens if after May, they have to start the whole process over again?
They would have to just re-advertise it.
Okay. All right, you're aware of that, Mickey, right?
Yes.
Okay. Thank you. Okay, the next is Planning Board File 240661, Commercial Industrial Residential Height and Setback Regulation Modification Citywide.
In this case, the commission sponsor is requesting this item be continued to the June 10th meeting.
Okay, do we need to move on that, or?
Yes, we do. We should take any comment on the request for continuance.
Okay, anyone here to speak on this item? Anyone
I
on
see
Zoom?
Nobody on Zoom with their hand
Okay, you want
raised.
to move it?
Motion to approve?
I'll second it.
Okay, all in favor? Anyone opposed? Okay, it's moved to June, correct?
That's the June 10th.
Okay. Next one is Planning Board File 250747, Vendor Appointments to Land Use Boards.
This is something the city is still working on this ordinance, so we advertised it for today's meeting, but it's not ready yet, so we're asking that the board continue this to the May 6th meeting.
Okay, anyone here in chamber to speak on this? Anyone on Zoom?
Nobody on Zoom?
Okay,
Motion to continue?
I'll second it.
okay, all in favor? Anyone opposed? Okay. Next one, Planning Board File 250758, 6701 Collins Avenue and 6625 Indian Creek Drive.
So this is a development agreement with the Deauville and the city. The city is requesting at this time this be continued to the May 6th meeting. I mean, it may not be heard by the planning board. This will be heard at first reading by the city commission on April 23rd. If the city commission wants to get input from the planning board, the idea is we continue this to the May 6th meeting. If the city commission does refer this to the planning board, it can be discussed in May. Otherwise, second reading by the city commission cannot happen before the May meeting. So at this point, in order to explore or to leave open all available options, the applicant's requesting that this be continued to the May 6th meeting.
Okay, anyone in chamber to speak on this? Anyone on Zoom?
There's nobody on Zoom?
Okay, motion?
Motion to continue?
Second it.
Okay, all in favor?
Aye.
Anyone opposed? Okay, so moved. All right, on to revocation modification hearings. Item Planning Board 210442, 743 Washington Avenue, Vendome.
And this staff report begins on page 11 of the board packages. So this has been before you for quite a while now. The current revocation modification hearing has been before you since the planning department sent a cure letter to the applicant on May 29th, and the first progress report was heard by the board on June 25th of last year. Since the last time this was heard in February, staff has highlighted in yellow the updates in terms of the, where the code cases are. Most notably, as indicated on page 13 of the board packages, there was a case regarding queuing on the sidewalk, and that case, one of those cases has been appealed to the special magistrate, which is scheduled for April 3rd. I'll ask Mickey to provide an update in terms of the outcome of that special magistrate meeting, but we are recommending at this time that the board hear from the applicant and recommend that the revocation modification hearing be continued to the June 10th, 2025 meeting.
Good morning again. Mickey Marrero, 200 South Biscayne Boulevard, attorney for Vendome. So appreciate staff's comments. Last time we were here, I believe it was in February, and we were told if there were no new violations and, going through season, spring break, Miami Music Week, all the fun stuff that happened on the beach, you would all discontinue progress reports. There have been no new violations. A lot of scrutiny on this place, as you guys know. They've been squeaky clean, nothing, not one violation, no complaints, nothing since that hearing. What Michael mentioned, there was a hearing. I found it very bizarre. I'm not going to spend a lot of time on it, but the violation that was scheduled, and it wasn't appealed, it was adjudicated already. This is the one from May that started this whole process. The queuing violation, when they did all the different clubs after that one shooting at a different club, this was that queuing violation from May. We never appealed it. We've discussed it here at length. We've modified our plan. We've fixed the issue. For some reason, the city put that May 2024 violation on progress report, special magistrate, April 3rd, which we didn't appeal. So we just showed up and said, we don't know why we're here. It's already adjudicated. Special magistrate, okay, no fine. That was the entire hearing. There was no appeal. So there was no reason for that really to go back. But it's not a new violation. It was only the May 2024 violation. Nothing's happened. The only violation they've even had since the summer of 2024 was the one on Halloween, which we've talked about at length, which was nefarious in its own, but nothing else since then. So we believe they've been operating
But
great.
is anything pending, are
Nothing.
there no appeals pending before the
Nope.
magistrate?
No appeals pending, no open violations, nothing new since that October violation that we've talked about. And beyond that, nothing since the summer. Nothing.
Okay.
Despite code going-
I had heard there were pending matters before
No, it was-
magistrate that hadn't been adjudicated yet.
The only one that is the one Michael mentioned, it was on the April 3rd magistrate agenda. I appeared solely, but again, we never appealed it, so it should have been closed back in May. The code was confused as to why it was there. The magistrate was like, fine, but I'm not gonna give you a fine, this is an old case. That was it. There was nothing else. Nothing pending, nothing open, nothing new.
Okay. Anyone here in chamber to speak on this? Anyone on Zoom?
There's nobody on Zoom with their hand raised.
All right, and the recommendation from the staff is to just move it one more month to June?
That's what we're recommending. It's up to
Okay.
the board.
Okay. All right, any questions from the board?
I mean, so is there something else on the horizon in terms of a complaint or something? I mean,
No, like I mentioned in the report, there's been no new citations or violations since we last heard from the applicant.
so I mean, I don't see a reason to keep this open.
I'm with you, Nick. I think that our last discussion was if there's no new, complaints, we were fine to move this through. I mean, if there comes a new complaint, they'll be back in front of us anyway. So I think instead of wasting everyone's time, and this is a slow season starting anyway, so I think it's a bit of a
Well,
waste
let
of
me
time.
ask you this, can we do something where we keep it on the calendar, but if there's no violations between now and then it can be canceled?
I wouldn't do that because I think if it was a progress report, I would say yes, but because this is an actual revocation modification hearing, so I think the board should take action to either continue it or conclude it without having that sort of criteria which we've done in the past. We're continuing it, provided there's no violations, the applicant doesn't have to come before the board. I think because this is a revocation modification hearing, there should be some formal action by the board to conclude it.
And they'll be back in front of us if there's another violation of their COP, right?
Correct. If there is a violation, then we would bring them back before the board. We would just have to start the revocation modification hearing process over again.
The whole idea last time about continuing it till now is to see what happened.
Spring break.
With spring break and to make sure that we would have power if they had another violation. And then, of course, if they didn't have a violation, they'd be done. And we don't do this I've never seen us leave this open for other places, just to see what happens multiple times after there's no new violation. So I don't understand why we're singling them out.
So do we want to?
And then, all right, last question, so if we close it out, you recommend that we terminate special events or not?
Well, I think that's what at this point, we're just recommending a continuance. We're not recommending a modification at this time to the CUP.
Okay. All right,
My whole thing, if you guys have a problem with their business model, that's a whole different thing. I don't see that based on what has happened, this all sort of came to, that culminated on Halloween. That was October. We're now in April, so it's, I just think that the issue was resolved. There haven't been any new violations. I'm sure that there were, just random checks by code many times. I see Mickey nodding his head, and so,
okay.
that's my.
Any other questions or comments? No? Anyone? Okay. Elizabeth, any questions? All right, so want to move it?
I'll make a motion to close this out and, I don't know,
And just to conclude the
to
revocation
conclude the
modification hearing.
revocation modification.
I'll second that.
All in favor?
Aye.
Anyone opposed? Okay,
Thank you.
good job, Mickey Marrero.
Try.
All right, progress reports. First item is Planning Board File 180252 928 Ocean Drive, which is the basic required 90-day progress report.
This is not before you due to a code complaint or violation. This is just before you due to the standard requirement of a progress report. Just for some brief history on this application, this was initially approved by the planning board back on April 30th of 2019 to include entertainment and an open-air entertainment on NIE with an occupant content in excess of 200 persons. They did not get their BTR to include the entertainment until January of this year. Their approval was held active due to many state extensions, So before you now, just as a typical progress report, since there have been no complaints or violations issued since they had the entertainment added to their BTR, we're recommending that the board conclude the progress report at this time.
Okay, sir.
Hi, good morning. Michael Pago, 200 South Biscayne Boulevard, here on behalf of the applicant and operator. Just here to answer any questions that the board may have.
Okay. Anyone in chambers speak on this? Anyone on Zoom?
There's no one on Zoom with their hand
Okay,
raised.
close the public hearing. Any questions from the board? Okay, someone want to move it?
I'll move it.
Okay, move to close it.
Second.
Okay, all in favor? Anyone opposed? That was easy.
There you go.
Thank you very much.
Thanks for coming. Okay, planning board file 210448, 235 23rd Street. Progress report for change of owner.
And this report begins on page 39 of the board packages. This is a little bit different because there actually have been violations issued. So for some brief history on this. On July 27th of 2021, a CUP, modified CUP was issued to the operator Miami Loud Holdings LLC as the operator of the neighborhood impact establishment. Condition 2, this is an unusual condition. Condition 2 of the CUP allows submission of an affidavit to transfer approval to a new operator or owner, but does require that a progress report be scheduled prior to the applicant's submission and staff acceptance of the affidavit. So the applicant requested that a progress report be scheduled before the planning board on December 30th of last year. They did receive their BTR for the amended operator on February 24th of this year. Now, as part of any progress report, we do a search of code citations and violations. And we did note that there was a violation issued initially for not having a BTR. That was back in December. That appeal was actually appealed to special magistrate and was denied. There have been other violations, as noted in our report, for having a promoted event, similar to what happened at Vendome, without having the appropriate notification to the police department. So because of that, we are recommending that the planning board hear from the applicant and continue the progress report to the May 6th meeting.
Good morning again. It's still Mickey Marrero, 200 South Biscayne Boulevard, here on behalf of Baccarat. Different venue here. So Michael's correct, and I'll give you a little bit of the story. So yeah, we are here because it was a change of operator, not because it was a revocation situation, but there are some little hiccups, and I'm going to address them each one. What happened with this venue, this used to be a club called Gala, and most of I think about 80% of the owners decided to just change the branding, change the name, and they did bring in a couple new partners. That occurred at the end of 2024. So they opened with the new name Baccarat, and that was a mistake. They contacted me at that time. That's when I got involved. They were licensed. There was a BTR. There was a CU 4A nightclub, exactly the way it was proposed on that property. The issue was they should not have been operating as Baccarat without going through this process. So they did get a violation for not having a BTR for Baccarat, but they did have a BTR 4A nightclub that had all the fire safety things and everything else on that site. It was just a naming issue. They stayed operating without the Baccarat name until early this year, when they did finalize through their licensing council a modification to the proper name and had to modify the liquor license, all the state licensing, the valet, and everything else. And that was a relatively painful process because of all the different parties and agencies. So as of the beginning of 2025, I guess February, they did have their proper Baccarat license and started operating under that name with that, going forward. The violation that was issued was, a mistake, and I spoke to them about it. They have some new people that they brought in to run the operations. There was a recent change in that ordinance notifying the police. I've stressed to them the importance and that they're not going to make that mistake again. It was, of all the different times they've had events, they did not notify one time in a timely fashion. So they did get the violation. We didn't appeal it because they were guilty, and I didn't want to go through the whole special magistrate process. I just told them, fix it, get your process right. They understand now what they have to do. If we need to come back to make sure it doesn't happen again, we're happy to do that, but that really was the only issue.
Okay. Anybody in chambers speak on this? Anyone on Zoom?
There's no one on Zoom with their hand raised.
Okay, any questions?
In terms of the business, you said there's a change in some management, but it has the business model changed at all so that it's now more promoted events like the other?
It's the same business model before, just a couple of the partners that were involved just were no longer part of the entity, so they changed, but 80% of the people were the same. They were not operating for, about almost a year before they reopened at the end of last year.
But is that, but I guess, so is it similar to Vendome where they have performances inside, they just notify the police, this time they didn't notify the police?
It is a similar business model, and they have been notifying every other time. This was just one where it slipped through the cracks, unfortunately. I think sometimes, like I mentioned, and again, I told them, and I spoke to the person that's in charge, and I made sure she was aware of the importance of this and the scrutiny on this. Sometimes someone's in town, they didn't have it well planned, and they get excited, they don't notify quickly enough. But again, not excuse, and now they understand going forward. It's a new person that was handling it, so I don't expect it to happen again. But like I said, staff's recommending us to come back. If you all want to make sure that they have this in order, you know, we're happy to come back. But otherwise, you know, there's really no other problems.
So, how can you fail to comply for 50 cent, but you can notify for every other one? I mean, that seems a little, that's what I'm looking at
The
right
email's
now.
the same no matter who the artist is, just a matter of the timing of when they signed them.
But-
Sometimes they don't plan that.
But that's a well-known quantity. I mean, so they just didn't notify them for,
No, it got out late. I mean, again, sometimes they find out the person's going to be available and it's already within the 96 hours, so they have to scramble.
Yeah.
But it was just one time out of all the other ones, yeah. I don't think it had anything to do with the particular artist.
okay.
All right, if there's no other question, I want to move it to the next, to
I-
continue to. Go
Just
ahead.
one thing for me is, if we move it, I'd rather move it to the June meeting, because then you kind of get Memorial Day.
Okay.
I would second
Go
that.
ahead and move it.
So I'd make a motion to continue this to the June meeting.
Can I
with
just say,
staff?
Second.
That
can
okay with
can I just
staff?
say one more thing before?
Sure.
before- Reading the description about the interactions that occurred during the investigation by code enforcement, I guess that was, you know, back in December.
Yes.
I mean, I'm sure you can understand what my thoughts on that are.
Yeah.
And it's, to me, it's totally inappropriate. There were several people who jumped in there. I'm sure if we saw the body camera, it would not be flattering for a lot of them. And I just want to make sure you speak with all these people. I mean, there was even somebody from the Collins Park, the president of the Collins Park neighborhood, who tried to get the investigation stopped. And I just,
Understood.
I hope
I
that you
read it
speak
too.
with them, because as you know, we're impressed when we see, the interactions with, sometimes with the Good Time Hotel, the interactions are really professional, and that goes a long way. And so when you see interactions like this, especially the code compliance people who are working so hard and doing the best job that they can, they're doing their job exactly that. And so you should talk to them. I'm sure you already have, and just that was a concern of mine, but hopefully we don't see that again.
If I can respond for just like 15 seconds. I read it, and I absolutely agree with you. That was before my involvement. I did explain to them the situation. What occurred there, just to paint a little color, because, the gentleman that was mentioned is someone we all know. I think it was like a grand opening. They had a license. They thought they were licensed. There was confusion with the name. So there was a lot of confusion as to why are we being shut down? We have this license, and that person saw there was a license. So there was a lot of confusion. That was not intentional. We've dealt with it, but I totally understand your view of it.
Cool, thank you.
Yeah.
Was Ray's involvement just as,
Yeah, I know it's bizarre that Ray was in there trying.
But I get it. It's like, but there's a license. I don't understand. I can see how that could have happened. I wasn't there, but
If anything, I thought he'd be like in favor of the codes.
no,
Yeah.
I think he was.
It was
It was a nice venue. I guess he was there having a good time.
Right.
It's all very
All right, so we have a
bizarre.
motion to continue it to June, right? Do we have a second?
Second.
Okay, all in favor?
Aye.
Anyone opposed? All right, we'll see you
Thank
then.
you all.
What's that?
Well, I said thank you.
Oh, okay. All right, next one is under progress report, planning board file 220518-818 Lincoln Road, again, a required 90-day status.
And this staff report begins on page 49 of the board packages. This is a progress report that's required by the CUP that was initially approved by the planning board on September 20th of 2022. The BTR was issued on January 16th. The progress report is required to be presented before the board within, I think it's 90 days of the issuance of the BTR. There have been no complaints registered and no violations issued as noted in our staff report, so we are recommending that the progress report be concluded at this time.
What's the name of the venue again?
It's Oro and Elixir.
Oh, it's Oro, okay.
Yeah, Oro.
The one above Milan, okay.
Not, very nice
adjacent.
place. It's
Yeah.
lovely.
Thank you very much. My name is Ian Bachakov with Ackerman, 98 Southeast 7th Street, Miami. Here on behalf of the CUP holder, Golden Era Hospitality, doing business as Oro and Elixir. Just here to answer any questions. Thank you.
Okay. Anyone here to speak on this? Anyone on Zoom?
There's nobody on Zoom with their hand raised?
Okay, any questions? Someone want to move it?
Motion to conclude?
Second.
Okay, all in favor?
Aye.
Anyone opposed? Okay.
Thank you.
Okay, the last progress report is filed, planning board filed 2046, 400 Collins Avenue parking lot.
And this is our last progress report. Actually, this is a progress report due to code violations. This staff report begins on page 57 of the board packages. Just some history of this parking lot. A CUP was issued back on May 22nd of 2007 to operate the parking lot after midnight as valet and self-parking. The CUP was modified to go under the current ownership, which is the Savoy Hotel Partners LLC. On February 27th of this year, a violation was issued regarding failure to maintain the lot in accordance with requirements of the CUP. We did send a cure letter to the Savoy Hotel Partners LLC on March 19th, advising them to appear before the planning board for today's meeting for a progress report. We did provide some pictures in the staff report in terms of the deficiencies in the parking lot. Now, we understand that the applicant has made efforts to address these concerns, and are going to provide some photos today. So we are recommending that the board hear from the applicant and continue the progress report to May 6th of 2025. And we do believe that this continuance would allow staff to inspect the property and make sure it complies with all the requirements. So although we are recommending that the board continue till May 6th, if in the meantime, staff inspects the parking lot and finds the lot meets the requirements, then we can administratively just revoke it from the May 6th agenda. I'll turn it over to the applicant.
Thank you, Michael. Good morning, Nick Noto from the law firm Bills and Sundberg. Our office is at 1450 Brickell Avenue, and I'm here today on behalf of Savoy Hotel Partners. This is a parking lot just south of Fifth Avenue just south of 5th Street on Collins, and we've had a CUP since 2007. I don't think we've had any code issues. The landscaping has always been really well maintained. As soon as my client found out about this, I think they spent upwards of $9,000 fixing all the irrigation, doing the needed landscape maintenance. I provided some photographs that I prepared for you today, my presentation showing to you. There we go. And you can see this is just the interior parking lot and then a view from Collins. Again, same photographs we can see. To us, we believe the parking lot landscaping is now in compliance. All the irrigation has been fixed and reinstalled where needed. And as Michael said, I know they haven't had a chance to go out to the site, but looking forward to continuing to work with staff to make sure that they're happy with the status of the parking lot. And if not, we'll come back and report on May 6th.
Is Eric, is he still the
Yes.
owner, your client?
Yes.
Okay,
Yep.
he's a good guy. Anyone in chamber to speak on that? Anyone on Zoom?
There's nobody on Zoom with their hand raised.
Okay. Well, I say that because I know that he's a very responsible operator, so any questions from the board?
So if we continue this to the May 6th, city goes out, sees there are no issues, you could just pull it?
Yep, we'll do that.
All right, let's make a
I
motion.
make a motion to continue to May.
I'll second it.
Okay, all in favor? Anyone opposed? All right,
Thank you, everyone.
all good, thank you. Okay, previously continued items. Item Planning Board File 240734, increasing and enhancing porous surface requirements for parking lots and driveways. And I'm sure everybody got it, but I received a pretty informative email from an architect about this. I hope everyone read it, but go ahead.
Sure, thank you. And this staff report begins on page 73 of the board packages. And this ordinance was initially referred to the planning board by the city commission on November 20th of last year. An ordinance was initially reviewed by the planning board on January 7th of this year. At that time, concerns were raised by the public and some board members regarding the proposal to no longer allow pools to count as part of the minimum pervious landscape area requirements. General changes to county review requirements were discussed as part of the reason for this change, and action of the ordinance was continued so that details of the county requirements could be provided. Now, I'm going to provide some background here. Currently, building permit applications, whether part of unincorporated Miami-Dade County or a municipality such as Miami Beach, are also reviewed by DERM, which is the Department of Environmental Resource Management. This includes, but is not limited to, permits related to new construction, additions, interior remodeling, change of use, demolition, docks, seawalls, and pools. As part of an amended county ordinance, which was adopted by the county on September 4th of last year, DERM will also now be enforcing new pervious area requirements in accordance with the amended county regulations. Currently, non-structural improvements, such as a concrete deck, pavers, or an extension of a pool deck are not reviewed by DERM, but are reviewed by Miami Beach for consistency with city regulations. Starting in March 31st of this year, DERM will be reviewing all of these standalone application types when not tied to a building permit for compliance with the county's new pervious requirements. Now, all municipalities, including Miami Beach, must provide confirmation that the city code meets the minimum standards of the county ordinance by December 31st of this year. If the municipalities do not meet the minimum county standards, then DERM will review the improvements noted above for consistency with the county requirements. Now, we did include as an online supplement, I think I emailed it to everybody. It's also included as part of the online packages for the public to see, is the, which is an 87-page commission memo dated May 21st of last year. And we did highlight in yellow and green the portions of that document that directly relate to the city's requirements and modifications to the pervious surface requirements. Now, we noted in our staff report, while swimming pools are counted currently towards the minimum pervious area requirements, they do not function really as pervious surfaces. A pervious surface is defined as one that allows water to infiltrate into the ground, contributing to groundwater recharge and reducing surface runoff. However, swimming pools are impermeable structures that prevent water infiltration, effectively increasing runoff rather than mitigating it. Further, with the increasing frequency of heavy rainstorms, pools often fill quickly and overflow. This is the case. I have a pool. My pool frequently overflows. Once you get more than 3 inches of rain, it overflows to the skimmer and the water goes into the yard. So this is something that's happening now on a more frequent basis. So we do believe that removing pools from pervious surface calculations reflects the functional reality of how they impact stormwater management and drainage. We also believe that removing this allowance for pools to count as pervious also creates more consistent regulations between the city and county. Otherwise, we'd have different calculations when the county reviews it compared to when the city reviews it in terms of the pervious area requirements. Now we are on the same page in terms of what counts as pervious and what is not counted as pervious. So we are recommending that the board review the ordinance and transmit this to the city commission with a favorable recommendation. I understand as well that some applicants have been concerned regarding they already have a permanent process or they have a land use board application that's been approved. So we have no objection to the planning board including an applicability clause subject to the city commission including that as well in the ordinance at this time. But I'll open up to the public for any comment.
Okay. Anyone to speak on this item in chambers? Coming up to speak, Mickey? Okay.
Busy day, wow.
It's like moving.
Are there any other lawyers in town?
I think I've cornered the market for the morning. Good morning again, Mickey Marrero, 200 South Biscayne Boulevard. So to Michael's point, we have a few applications. I'm involved in one in particular, but our office has several where, as you know, these things take time. Some of them require planning board, lot split, then DRB, a lot of architectural work. So while we understand the ordinance going forward, we're just asking humbly that applications that have already, if you go to pre-app, that means you've got plans already done. You spent tens of thousands of dollars on an architect, and these are single-family homes. And it's the smaller lots that are going to have the bigger problem because you have less space to work with. So if you've already designed it to code as the code reads today, if this ordinance takes effect today without applicability, then you have to start new plans, and it's a mess. So we would ask that the applicability clause that was distributed, I think Matt Amster sent something to you all, that be included with your recommendation going forward. Thank you.
Okay. Anyone else speaking on this item? Anyone on Zoom? Michael, anyone on Zoom?
There's nobody on Zoom with their hand raised?
Okay. Close the public hearing. Any banter among the board?
I've
Go
got-
ahead.
I definitely think that the applicability provision should be included, but my question for staff is, and I'm not saying the board would vote this way, but if the board voted with an unfavorable recommendation, then what would happen? We're not in compliance with county requirements, and then on every future application Durham has to review?
Well, yeah, your recommendation is just a recommendation to the city commission.
Correct.
Ultimately, the city commission will take that into consideration when they adopt the ordinance or not. But yes, if the ordinance is not at least as restrictive as the county, then the county will continue to review those previous requirements.
And is there any type of threshold, meaning, to Mickey's point, if you're dealing with a, larger lot, it's easier for a single-family kind of homeowner to get through that process than someone who has a smaller lot and they're trying to do work to their home, and now they can't have a functional driveway or whatever that might be because of,
Well,
these requirements.
although we are increasing the requirements for pervious landscaping in the front yard for driveways, we do also allow you to use porous pavers to count as part of that requirement. Previously, none of that counted towards your pervious requirement. So that is one of the allowances that we are doing, is to offset the stricter requirements, now allowing you to have part of your porous pavement count towards your pervious landscape requirements.
Got it. So whereas previously it had to be landscaping.
Correct.
Now you're able to use those pavers, which
Correct.
would count. Got it. And has staff heard from any architects, builders, whatever that might be, as to the potential impacts for
Well, we have
the
had concerns, like you
homeowners?
mentioned, in terms of properties, have smaller properties and may want to add a pool, to their property and they're already built out. There are provisions where somebody could apply for a variance in that type of situation.
I mean, because my concern is that this now puts, it's really kind of negatively impacting, let's call it the mom and pop type homeowner who wants to make modifications to their home, but can't afford to be in compliance, or they just reasonably can't be in compliance.
If somebody is already non-conforming right now and they redo their pool, or they redo the entire house, as long as the value of the renovation is under 50%, they wouldn't be required to come in compliance with these requirements. So they could redo their pool, they could redo their deck area, as if they were exceeding 50% of the value of the improvements, then they would be required to come in compliance with the current regulations.
Got it.
Michael, question. Sometimes when applicants are in front of the board, either DRB or HPB, they may ask for a variance for required front yard, side yard. So if they do that and they're allowed to provide less than what's required, wouldn't that affect these numbers as well? In other words, wouldn't that be sort of a end around to get around this, some of these requirements?
Well, we would still count so for example, let's say you have a required rear setback of 20 feet, and the board approves a variance to allow you to encroach 5 feet into that setback. That area of the building is going to count against them in terms of the pervious requirement. So we still take the calculation from the required setback, unless they were to then ask for a variance from the pervious landscape requirements.
Okay, thanks.
One of the architects had written about asking that courtyards be taken into consideration. So are we including some consideration for courtyards?
We don't have that right now in terms of our consideration. I understand the concern there, and in terms of the way the county looks at it, they look at a percentage of pervious space based upon the entire lot. So when the county looks at that, they would consider that courtyard area to count if it does consist of pervious material in terms of the overall pervious requirements.
But ours does, but the city's doesn't?
Because our lot coverage and pervious requirements are based upon your front yard, street side yard, and rear yard. I mean, you could recommend maybe the city commission explore including an overall lot coverage that's consistent with the county, how the county calculates the overall lot coverage for a property.
Which gives the architects a little bit more freedom in taking advantage of those spaces, right?
Yeah, I can see that, because then somebody could offset their pool with an interior courtyard that consists of pervious landscaping.
And then it becomes consistent with the county.
Right, and we did provide a diagram, so right now, like on page 70 of the board packages, the county does give different requirements depending on a small lot versus a larger lot. So if the lot size is less than 5,500 square feet, this would be our smallest RS4 lots. The county requires that 20% of that lot area be pervious. And for lots larger than 5,500 square feet, the county requires 25% of that area to be pervious. And if somebody does have a courtyard, that would contribute towards the pervious
How
requirements.
does the board feel about us, just to give a little bit more of elbow room in the design here?
I'm definitely in favor of that. And I guess my only other reservation is there's a big difference between a 5,000 square foot lot and a 20 or 25,000 square foot lot. And there's a lot, I mean, we know in Miami Beach, there's a ton of lots that are either 7,500 square feet or 10,000 square feet. And those are two of the most common lot sizes for single-family homes in Miami Beach. And you're almost lumping them in with the, you know, the 20,000 square foot homes or lots. And I don't think that that's necessarily fair. So I in addition to, you know, especially since the 5,000 square foot threshold is so close to 7,500 square feet, it's a totally different totally different analysis, but almost the same lot size. And so I guess my proposal in addition to that would be to add maybe some sort of middle ground for the average lot size, giving them more freedom as opposed, you know, maybe instead of 5,000 square feet, putting that up to like 7,500 square feet or even 10,000.
We can't modify the county requirements.
Yeah.
No, I know, but I'm saying but isn't there
No.
so we can't do anything separate from, but ours is different though, because we don't include, ours is only the side and backyards and front yard, right?
But the county would include a courtyard in terms of the pervious area requirements.
Yeah, and I liked that we're going to change it, as you proposed, to be consistent with the county. So any change that isn't consistent with the county defeats the whole idea.
We also
We're
don't
not
wanna-
creating our own, we're trying to be consistent, and I think that's a great idea.
But, I mean, based on the nuances in the city, to Jonathan's point, we can't have any kind of recommendations to the commission to include some other type of
I think we
nuance?
can recommend it and study it and see how that impacts and if that would result in something that's less strict than the county. I know right now, what we don't want to do is have somebody be allowed to make up the requirement by having a large courtyard and then have too much hardscape facing the neighbors at the rear or facing the street or the front. So we don't want to have that allowance for the pervious area for a courtyard offset the requirements that are allowed facing what the neighbors see. That's also a concern.
I would, be really supportive if the commission would consider Jonathan's kind of threshold of, I would prefer, let's say, 10,000, which seems to be kind of the average lot size around the city, so that you're not kind of overly.
Would you be
penalized.
recommending that we have a different, because what I wouldn't recommend is changing the definition for pools, but maybe having, if you're saying, decreased, pervious area requirement.
Yeah,
for
essentially, it's
smaller
this
lots.
chart, but instead of lots less than 5,500, it's lots less than 10,000 square feet.
Or is there any, so does the staff have any other angle for us? I guess everyone's concern is for the smaller lots, right?
Well, I mean,
And,
at the-
so is there anything that the staff can recommend that we can sort of explore as options to make sure that the smaller lots, have a little bit looser,
Like I say, it's hard because if we modify and say that, for example, right now the county says for lots larger than 5,500 square feet, they have to go to 25%. If you want to raise that to 10,000 square feet, then they'd be non-compliant with the county.
But what about for the ones, like the renovations that aren't reviewed by Durham? So like just making the modification, non-structural improvements such as the concrete deck, pavers,
So those are all items that currently aren't reviewed by Durham, but Durham is going to be reviewing those.
they're gonna start.
They're going to start reviewing those.
All right, well then, if you're saying that we can't do anything.
Yeah, so
about
we
it.
essentially have to approve as is. I mean,
Well, but I would say just at the minimum.
we-
with the
With the.
Applicability clause, but can we do a
clause.
separate motion with recommendations?
Yeah.
Yeah, so
The first motion is motion to approve with a favorable recommendation.
Correct.
And then we're talking about it before I'm making my motion.
Right, and then the
The
second would
second
be
one
that-
is to make a motion to make a recommendation for an applicability clause as well as the carve-out to keep it consistent with the county so that interior courtyards are excluded from the calculation. Or included in the calculation.
Correct, so go ahead and make the motion.
Was it included in the calculation or excluded?
I think to be part of the pervious, to count towards part of the pervious.
So I'll make the
area.
first, thank you, sorry, I didn't mean to interrupt you. I'll make the first motion to approve with favorable recommendation.
Okay.
I'll second
Melissa,
that.
second?
Yeah.
Okay, all in favor?
Aye.
Anyone opposed?
And that could include the applicability that you referenced.
Okay, so that
Oh,
would
that
include.
can?
Yes, that's
Okay, I
Okay,
think
so
that's-
it's favorable with applicability,
right.
okay. And then the second, go ahead, Jonathan.
Motion to bring the city's code to be consistent with the county's code in that the interior courtyards are included in the calculation.
I'll second that.
That's the recommendation, okay. Melissa seconded, all in favor of that? Anyone opposed?
Just want to make sure that the applicability clause that you have includes if they've had a pre-app,
Yes.
formal
Yeah.
pre-app, or submitted a building permit, because some don't
Yeah,
need here.
the applicability clause that I have is for any land use board application that paid an initial application fee, obtained a land use board file number, and presented a proposed design at a pre-application meeting with staff.
And I think we also had alternatively, some
Or
applications don't
obtained a
need
building permit process
process
number.
number. Thank you. Yep.
So just to be clear, Michael and Nick, so if there's a new application that happens between now and the commission meeting, so does the applicability start? I'm just trying to, to be clear, so when does the are we looking at new permits between now and the commission will fall under this new?
Two things. I think the effective date of this ordinance was delayed anyway. So the ordinance takes effect 60 days following adoption.
Okay, so
So
after
if this gets to
commission.
the city commission in May or June, it still won't apply for another 60 days.
Okay,
And then on top of that, with the applicability clause that the board just included in its recommendation, that would capture anybody who's already initiated the process.
all right, just so it's clear for the clients of where we're going with this, right? Okay.
Alrighty, moving on.
Sorry,
Oh, go ahead.
one question on that. So in terms of any recommendations for changing the lot, kind of threshold, that's something we could recommend to the commission, or because it's not consistent with the county, it would essentially just not be considered?
You could recommend changing the thresholds, but not in a manner that is less stringent than the county.
Got it. So essentially, increasing the threshold doesn't matter.
Right.
Okay. One more question. Retaining walls. So right now, the city, I think they permit using kind of the PVC vinyl retaining wall. If I, as a member of the planning board, wanted to bring up for discussion, not allowing that, and only allowing, let's say, concrete retaining wall, how would that work? Does that kind of factor
Well, I
into
think, so the
this?
county is requiring now, when you have a grade difference, they are requiring a retaining wall be
Right,
installed.
but there's a difference between the PVC vinyl retaining walls and the concrete retaining walls that,
Let me see if the ordinance right now mentions, I don't think we mentioned the material for retaining walls.
I didn't see mention of the material, but personal experience.
We do require that the retaining walls be finished in
Yeah.
a acceptable material.
They don't all work the same, so.
Materials are usually governed by the building code, unless we have, specific authority here to
So
specify
changing
one
building
material
code
over another.
happens at, I guess, how could it be established what material will be used through building code?
Well, so right now, if you have a retaining wall on your front property, we do require that be finished. You can't have like a steel, piling going through with that steel. We do require I think a stone, a durable material, stucco finish. We don't require that along the side elevation. There would be a further amendment, I think, to the single-family regulations. I think that would be separate from this ordinance.
And I don't think we can distinguish between types of materials.
So who could do that? Or who can make that determination?
I mean, the building code is a statewide code. We can look into it, but my initial thought is that we wouldn't have jurisdiction to specify one material or another.
Got it.
But Nick would have to go through the building code to raise some concerns and get the building code to review some of the current materials that are used? Is that where he would go?
The building code, generally speaking, is silent as to one material or another, right? It's, so I don't know that we could do that. I don't know that we could specify that the retaining walls have to be concrete and not vinyl.
So which level, where does it go to? Who, is this all under the
think we
code of
could-
the
do we-
county, or is it state, or is it?
Well, I think we can't require a certain material for the actual retaining wall, but maybe we can require that it be finished in a certain material,
Okay.
which I think is the concern, right?
Does
So
that answer, I guess you're trying to go a little deeper and trying to figure out who.
Yeah, I mean, I've just seen, I know that I'm dealing with it with my neighbor. I know other kind of friends of mine have dealt with the same thing with the water retention. So those that have kind of the concrete retaining walls, it works. Those that don't usually have some type of issue. So I was curious if that's something that could be dealt with as we're talking about kind of.
Actually, Michelle just brought up a good point, if I can just read from the code here. So we do have a requirement now that says retaining wall shall be finished with stucco, stone, or other high-quality materials in accordance with the applicable design review or appropriateness criteria. So it is a requirement now,
Got it, okay, so that's a new
not
requirement.
just in the front.
Okay,
And that's as far as the finishes or
That's the finishes,
Okay.
that's just the finish.
Okay. I think that, yeah.
thank you.
All good?
To answer your question, Melissa, the building code is amended by the Florida Building Commission, which is a statewide body.
Okay, thank you.
Okay, we are on to new comprehensive planning code amendments. First one is Planning Board File 250744, commercial use of single-family houses on 121 of the books.
This ordinance was referred by the City Commission on February 26th of this year. And what this does is further strengthen the prohibition on using a single-family home for commercial purposes. It does prohibit the sponsorship of an event in a single-family home by a for-profit entity, and prohibits the promotion of any party event via social media platforms. On page 124 of the board packages, that includes the additions in terms of what's prohibited for single-family homes, noting that, for example, any advertising, marketing, or promotion of any party event, assembly, or gathering in any print, film, social networking platform, or any other media, that would be prohibited. And any party event, assembly, or gathering is sponsored, managed, or promoted by any entity other than a charitable, religious, or political organization or candidate for public office that has received a 501c3 or other tax-exempt status in accordance with the applicable election laws. So this is just further strengthens somebody using their home as a party house.
So there's no permit that can be obtained, it's just a pure out ban?
Right,
Okay.
This would be
all
for a,
residential homes all through the beach?
right, this is for a for-profit entity. It doesn't affect the nonprofit
Right.
and the political parties.
But if someone wants to have a birthday party in their backyard and they have music and all of that.
That's fine. We're not promoting it as a, open to, promoting it as a party on social media.
So you don't have to have a special event permit or,
Well, it depends on how,
I'm just saying, if I'm having a birthday party,
Yeah.
I don't have social media, but I put it on Instagram, hey friends, please join me. Is there some gray area there where code is gonna come in and shut down my birthday party? If you're both
I think
looking at
there's
each
a
other,
difference. I think there's a difference
I know what
between
this is.
No,
I think there's a difference between posting an event on social media and inviting your friends and family versus posting a special event on social media and opening it to the public.
and having 50,000 people
agreed, but
there.
code will
Yeah.
view it with that nuance and distinction, right? Okay.
I mean, the key is advertising, because if they don't advertise, it's like, how do you find out? But, I mean, that's,
Send invitations.
Huh?
You can send invitations.
No, I'm for this. I'm just, the enforceability is always an
Right.
issue, but anyway.
I think this was directly linked to what we had dealing
Yep.
during Art Basel,
Oh, yeah.
the Venetian and
Yep.
Hibiscus
Our
Island.
island, they all
And
were
so this
killing.
is, we had, houses that were posting on social media for these big parties that were commercial, obviously, with boats outside advertising for it. So I think that's what we're trying to defeat here, and it's very welcome. The city did an excellent job during Art Basel, the mayor, the city manager, the code compliance, and the cops in helping us deal with the chaos that we had during Art Basel. So we're trying to prevent this to happen again for New Year's Eve and Art Basel and those big times of the year. But I'd like to some of the concerns, we just got to make sure that this doesn't get crossed over in some of the personal hosting events. So we just want to make sure that we're feeling comfortable that not the wrong people are targeted here.
And Nick, just as an aside, that'll sustain legal scrutiny? Like if a homeowner were to sue over that
Right.
before?
Yes.
Yeah.
Okay.
Isn't there like a loophole, though, that if somebody wants to have like this big party at their house during Art Basel or whatever, as long as they say a portion of the profits are gonna go to charity, this nonprofit?
I think that's part of the reason for this amendment, right? Because where right now, an event like that might not be covered by this ordinance. The ordinance includes events that are maybe not necessarily charging admission, but are being widely promoted on the internet or in some other medium, or events that are otherwise, again, not charging admission, but are otherwise sponsored by, let's say, some, a private corporate sponsor, somebody in the, other than a nonprofit or political party.
And if it is a nonprofit, do they need some type of permitting or just, they can just have a party?
Are we looking at like for beyond 100, might not have the numbers right, but if I remember discussing with a couple of commissioners, is anything beyond 100 or 150 people, guests, you would have to apply for a special event permit and you're allowed a certain amount per year at your home.
I think I remember that.
I think that was addressed in separate legislation that is not in the land development regulations. That was just reviewed by the land use committee. And I don't think the threshold is in this ordinance. I think that's governed by separate code. You happen to know, Michael, the number of people?
Looking for, I don't
But there is a
know.
process going on right now with
Yeah.
either 100 or 150 people, where if you're going to have an event at your house, that you just got to go through a permitting process.
I remember
Even if
that.
it's a private, over a certain amount of guests, and you got to go through a permitting process, right?
Right. So this is a two-part. This particular item before you is an amendment to commercial use of single-family property in the land development regulations. There is a separate amendment to the city code outside of the land development regulations that identifies specific factors that would make a party at a single-family home commercial in nature. And one of the indicia for that was a minimum number of people, and I can find that for you, but it's not in this ordinance.
I think it's just important for us, I know it's a separate
Yeah.
item, but for us to put in a context, not into a vacuum here, what we're saying
course.
yes to, and just so that we know that property owners are not, it's not all of a sudden no one can have a party, we just need to know what we're saying yes to.
All right, in the meantime, anyone here in chamber speak on this? Is there anybody on Zoom, Michael?
There's no one on Zoom with their hand raised?
Okay, close the public hearing. While you're in the information, any other questions from the board? Okay, someone want to move it?
I'll make a motion to move.
Okay,
I'll second.
favorably, I assume.
A second.
Favorably, yes.
Okay,
I think it's great.
you have a Hill moved and Elizabeth seconded. So all in favor?
Aye.
Anyone opposed? Okay. Yeah, and just for our own edification, if you find the answer to the other question, but we'll
Of course.
move on. Okay, next is Planning Board File 250745, website advertising for LDR amendments.
And this ordinance this staff report begins on page 133 of the board packages. And this ordinance was referred by the city commission on February 26th of this year. You may remember, the city commission has adopted regulations allowing the typical land use board application to be advertised now on the county website versus the publication in the Herald. This would expand that to allow amendments to the city code to also be advertised on the same county website. Like before, this would also, be less costly for the city in terms of these ordinances in terms of having to advertise in the Herald or other newspaper, allow us to more speedily or rapidly advertise items as needed. So we are recommending that the planning board transmit this to the city commission with a favorable recommendation.
And this is something that was approved by the voter referendum that.
Yes, sir. Yeah, we did reference that. Yeah, correct.
With the charter review advisory board.
Anyone to speak on this in chambers? Anyone on Zoom?
There's nobody on Zoom with their hand raised.
Any
Can I-
questions?
Yeah, can I make a suggestion? I'm all in favor of this, but, you know, when you go to the city's website, sometimes that could be a little difficult to find these notices. Maybe sort of on the main screen, the minute you go to the website, some little button to press that'll take you to or click on, to take you to the county website. Something that's clear that, you know, if someone's looking for these notices, they can just click on that and it'll go right to the, wherever that site is on the county's website.
Yeah,
Maybe-
a button with a hyperlink.
Yeah.
Maybe that's something that the commission can work on with IT.
Yeah, for sure. We can
Yeah.
include that recommendation.
I would support that.
That's a good idea.
Motion to approve with a favorable recommendation?
I'll make a motion. Approve it.
Okay, second, well, okay, so Elizabeth second. Okay, all in favor?
I
You, Marty,
didn't
you-
hear.
Yeah, all in favor?
Aye.
Anyone opposed? Okay. Next is Planning Board File 250746, vote requirement for the release of covenants requiring non-transient uses.
And this staff report begins on page 143 of the board packages. So the board, we've seen several ordinances come before you that have incentives for the conversion of non-residential uses to residential spaces and incentives associated with those types of change of uses. What this ordinance does is codify that whenever someone's taken advantage of those incentives, that in order to release that covenant that requires the residential use, this would require a 6/7 vote of the city commission to release any sort of ordinance where someone's taking advantage of those incentives.
So if they wanted to go back to transient use?
Yeah, they would have to, the city commission would have to release that covenant by a 6/7 vote.
I think it's great.
Anyone in chambers speak on this? Anyone on Zoom?
There's nobody on Zoom with their hand raised.
Okay, any questions?
Yeah, I have a
Scott?
question, and it's, I'm in favor of this. I don't get the wrong idea, but a question for Nick. Nick, you know, we're seeing this being added to a lot of sort of development agreements and a lot of things, and it seems like it's portrayed as, well, once this is in, there's no way that short-term rentals are gonna happen here. But, you know, my understanding is, let's say, you know, a project moves forward, you know, there's the agreement, and this is in the agreement, and, you know, a year or two, once the building is up, let's say it's a condo and some of the unit owners are starting to do short-term rentals, or it's an apartment building, one owner, and he can't rent them, so he's doing short-term rentals. My understanding is there would have to be a lawsuit filed, or to, I guess, get an injunction for him to stop, or whoever it is to stop, or someone's got to sue for damages. So my question is, right now, if somebody's doing short-term rentals illegally, code compliance says to do an investigation and they go to the special master. If in the future, a project that has this part of the, has this in their agreement, is doing short-term rentals, what would be the process to, in other words, who's going to do that? Is it the city? Someone's going to say there's short-term rentals, code's going to go out, do an investigation, basically just like they do now, but instead of going to the special master, is the city going to file a lawsuit? How is that going to work?
And that's a great question. So just stepping back, this is an approach that we have come up with over the last couple years, so that when the city commission is considering zoning incentives for a particular type of development, as of late, the city commission has been prioritizing long-term residential development, that in order to be eligible for those incentives, whatever they may be, a property owner is first required to record a covenant restricting prohibiting short-term rentals on the property. because we are including that as an incentive in the respective ordinances, creating these development incentives, it is something that code compliance could enforce. It's also something that the city could enforce by filing an action in court to compel a property owner to comply with the covenant. But this is an approach that we came up with because of the state law preempting local governments from adopting new regulations on the frequency or duration of short-term rentals. What we on the city commission have decided is moving forward, whenever we consider new development incentives, you have to record this at the approval stage. And because it's in the code, it could be enforced by code compliance.
Yeah, and I just, I bring it up just because it seems like we're seeing more of this, which again, I'm 100% behind, but it just seems to be portrayed as sort of like, there's just no way once this is included, there's no way there's going to be short-term rentals in that project.
I think everything is like that, anything could be undone.
True.
That's sort of what.
Yeah, what I'm saying is it's, even though these are in there, this would be in an agreement. You still have bad old operators that will do that, and it's basically still the same process, maybe more onerous now to stop that than maybe code compliance going in front of the special master.
I think it's the other way around. I think right now where we have no recourse.
Correct. I
When
understand.
when a property owner in a district where short-term rentals are permitted, we have no recourse there, right? Unless there's some other violation of the code, unless there's a noise or sanitation or parking issue. So what this tool allows us to limit transient rentals in districts where they are otherwise permitted, and under state law, we couldn't prohibit them if we wanted to.
I understand. Look, like I said, I'm 100% behind this. I just, it just seems portrayed something like it's going to cure the problem when, but like you said, it's another tool, and that's, good for the city. So I'm in favor.
All right, I think we closed the public hearing if someone wants to move it.
Motion to approve with a favorable recommendation.
Second.
Okay. All in favor?
Aye.
Anyone opposed? No. Okay. Good comments, though, Scott. I agree with you. Planning Board file 250748, variance fee waivers for building recertification.
And the staff report begins on page 147 of the board packages. This ordinance was referred by the City Commission to the Planning Board on February 26th of this year. What this ordinance would do is allow the City Commission to waive the Land Use Board application fees related to variances associated with the building recertification process. So for example, if somebody had to rebuild a wall of their pool deck and it was a non-conforming setback and they were exceeding the valuation that would require them to comply, this would allow the City Commission to waive the fees associated with that variance. This is only associated with the building recertification to sort of eliminate any sort of impediments to recertifying a building. I can't think of anybody recently that's gone through this process. This is just, perspective in terms of in case this does happen, or maybe we have a lot of 40-year certifications coming up, or, it's 40 years and I think every 10 years after that. So this would just allow an easier process for, and this is for residential buildings that have to go through this recertification process, allow the City Commission to waive the application fees. We are recommending that the board transmit this to the City Commission with a favorable recommendation. And this does indicate that the associate would have to sort of present a financial hardship in terms of their application.
Through what, like an affidavit or something?
Up to the City Commission. The City Commission would review whatever documentation they're submitting to present their financial hardship.
Right. Okay. Anyone here in chambers speak on this? Anyone on Zoom?
There's nobody on Zoom with their hand raised.
Okay. Any questions? Okay, someone want to move it?
I'll move it. Favorable recommendation.
I'll second.
Okay, Elizabeth, all in favor?
Aye.
Anyone opposed? Okay. Cruising through today. All right, next one is Planning Board file 250749, setback regulations for air conditioning units.
And Giselle's going to go over this ordinance. Giselle?
All right, the Mayor and City Commission of the City of Miami Beach, Florida, amending the Resiliency Code of the City of Miami Beach by amending Chapter 7 entitled Zoning Districts and Regulations, Article 5 entitled Supplemental District Regulations, Section 753 entitled Supplemental Yard Regulations by amending the setback encroachments for air conditioning and providing for codification, repealing, severability, and effective date. This is a recommendation to transmit to the City Commission with a favorable recommendation. A little bit of history about it. On December 11, 2024, at the request of the Commissioner, they preferred a proposal pertaining to setback regulations for single-family homes regarding, for residential districts, I should say, and air conditioning units. On February 26, 2025, at the request of the Commissioner, Kristen Rosen Gonzalez, the City Commission referred the attached ordinance. This is for package terminal air conditioning units, like mini splits. So this is to modify some of the setback regulations. A little bit history about it. These are usually in hotels, living senior facilities, and these existing multifamily units. There usually are an option for it to be a little bit less cost burden since they're affordable and energy efficient. What we've seen is that with these existing apartment buildings, they tend to sometimes not meet necessarily the setback regulations, and these are usually for like life safety, code requirements, and it's just an option so that it's not a bit of a cost burden to property owners. So we did decide to recommend some of the land development regulations to include in some of these residential districts. Some of them include central air conditioning, mini splits, and PTEC systems, so that they can occupy an interior rear yard. This would allow them to have a minimum 18 inches within the setback. They would still have to comply with the height requirements, 10 feet above the current flood elevation. They still can't be visible from the right of way, so that is not necessarily changing. This would include specifically in the RM1, RM2, RPS1, and RPS2 residential districts. And the other modification that we're clarifying a bit is that in terms of generators, AC units, some of those regulations are not necessarily going to be modified. However, we're including that some of these districts, such as the RM2, RPS1, and RPS2, are a little bit more in line to the RM1 that already exist in these regulations. The other thing I wanted to note that regarding the PTEC system is that for buildings existing as of January 1st, 2015, those are the regulations that will take in place. So these are the existing buildings prior to January 1st, 2015 that will take place and having a little bit more of a setback to accommodate 18 inches within the property line. Anything after January 1st, 2015, they still have to comply with a minimum setback of 5 feet. So those are some of the modifications to simplify.
Thanks, Giselle. And right, just for some additional input, right now, the reduced setback allowances for air conditioning units in the side yard only apply to the RM1 district. So if you're an RM2 district, you can't take advantage of even the 5-foot setback for AC units. So this expands what's allowed now in RM1 to the RM2 and RPS districts, and then does also now allow reduced setbacks. For example, a lot of these older buildings only have a 5-foot setback. So in that case, they can't put anything within the side yard. It can be cost prohibitive to add to the roof. So this allows those mini split units to be installed within the side or rear yard.
Also, just to also clarify, a lot of these, either non-conforming buildings, they tend to already have a minimum 5-foot setback. So it's almost impossible to, install some of these mini splits. So this is just to kind of expand a little bit the setback so that people are able to actually locate these units in like an interior side or rear yard.
Okay, thank you both. Anyone here to speak on this? Anyone on Zoom?
There's nobody on Zoom with their hand raised?
Okay. Any questions? Comments, motions?
Sounds pretty sensible. I'll make a motion to approve.
Okay,
Second.
okay. All in favor? Anyone opposed? No. Okay. I think the next two are companion items, I believe. Planning Board File 250750, RO District Regulations for Non-Conforming Uses in Alcohol Sales.
And we'll take the next two items together, and the staff report begins on page 159 of the board packages. These ordinances were referred by the City Commission on February 26th of this year. So right now, this pertains to Properties along the east side of Alton Road between 12th and 14th Street are currently zoned residential office on the city zoning map. These were originally constructed as single-family homes, and prior to the designation of RO, were designated as CD2, which is commercial zoning district. So that's where we have,
Like the dentist's office, yeah.
yeah, the code does now allow residential office, so dental offices,
There's a new
other
urgent care
architect's
there.
office, those are allowed in the code right now. We have a non-conforming use, which is the nursery that's been in place for so long. Retail sales are not allowed now in the RO district. This would allow the nursery to expand their cafe, because they also have a cafe, would allow them to expand their cafe operation to include the sale of beer and wine. So this would allow the limited expansion for the sale of beer and wine, only for sale for consumption on the premises only, provided that the number of seats not exceed 10, the area not be expanded beyond what it is right now. So it really is focused to this limited area and only applies to this essentially is the garden space right now, to allow them to offer beer and wine for sale on the premises only.
I'd like to ask a question. How is this not spot zoning? If RO doesn't allow alcohol, but we're going to say RO in this one location does,
Well, no,
I mean, why can't they apply? Isn't that a process for them to apply a variance and get a
No, you
liquor license under conditions, or
no, you can't get a variance for.
change their zoning? I mean, why are we, doesn't this open it up to other ROs?
It's allowed in any RO district that meets the requirements of that has an existing cafe.
Yeah.
That wants to sell beer and wine. So essentially, this only applies to this.
Oh, so it's gotta
particular
be an
property.
existing cafe.
Because
Yes.
this is the only one in the city?
Only one in the RO district.
Okay.
So they couldn't create a new cafe. It's
Right,
gotta
this
be
does not-
And this doesn't apply to other locations? There's no one else in the city that this could possibly apply to?
We have an RO district in North Beach, but there's no existing cafe that's there, so they can't.
They
wouldn't be able
can't
to-
put one in?
They can't put one in, right.
Okay. All right. Thank you.
It's an adorable cafe. It's a little French cafe, and I would support
And you can't,
this.
and you can't get a variance for use, so this is the only option is to
This is
amend.
the only way and
And
the
it's 10
only
seats.
one.
I mean, it's
So
not-
we're not just picking
Correct.
on us. I just wanted to clarify.
Yeah, no, good point, well taken, but
Yeah.
yeah, it only applies to this one.
Good.
Okay, did I ask if anyone's here on this? Anyone on Zoom? No, right?
There's nobody on Zoom with their hand raised.
Okay. Someone wanna move it?
I'll
One,
move it.
one quick question.
Sure.
Do we know the current hours of operation for the cafe, the current hours?
I think they close at like 5 o'clock, something like that. I mean, it's literally in the back of the nursery.
So we do limit, so right now, it basically requires that the indoor seating must close no later than 10 PM, and outdoor seating must close no later than 8 PM. And
No,
if the city ever amends the hours of operation in the future, they would have to comply with those amended hours of operation.
That's current. I mean, I'm leaning toward, being in favor of this. Just my concern is, I mean, as Elizabeth just mentioned, you said they close at 5, so now.
They're not even open.
They're just sort of
I mean,
expanding
They're
to be
just
a-
kind of in the back. They
Yeah, I
actually
know
are.
where they are. I know they,
Oh, okay.
I was in high school when I picked up plants from there, so they've been there a long time.
That's Gus.
Behind there, by the way.
It's just a little cafe. I
No,
mean-
behind them.
Single-family homes.
Oh, yeah.
Okay,
Yeah.
so that's what
There's
you're,
yeah.
no music, there's nothing, I mean.
Is
It
there-
looks- It sounds harmless, but it is kind of a funny sort of approval to basically, you're trying to help one business that was trying to, increase its income, and we're changing. Maybe the business concept needs to change, not that, I would love to see them stay forever, but I just find it kind of weird that here we are deciding on this, on the basis of one business trying to just round up their profit at the end of the month, and I do.
Should
feel
also
a little
mention too
awkward
that
about it.
this is located within the expanded Flamingo Park Historic District, so they are restricted in terms of, coming in, and someone's not gonna come in and demolish what's there and build a brand-new building because of those restrictions. So it does allow them to, have the city take in consideration the restrictions on that property and allowing them to, maintain the property and gain income from it.
all right, and right now, they would have to close the outdoor at 8?
Correct.
Okay, all right. All right, any other questions? All right, someone want to move it? Did someone move it?
I will.
Not yet. We can take a motion, I think, for both, right?
Yeah,
Yes.
I'll make a
Liz?
motion to approve favorably.
okay. Can I get a second? No second? Jonathan?
Second.
Okay. All right, is anyone opposed? All in favor? Okay. And that was for both, right? We were
Right,
allowed to
got
do
it,
that?
for both.
Okay. All right, well, shockingly, we're on our last item. Planning Board filed 250753, distance separation exemptions for adult material in retail cosmetic stores. What a title.
Did you guys actually try to scratch out the?
No, I don't know why.
Was that a dirty word?
I don't know why that is like that. Yeah, interesting. So this ordinance was referred by the city commission on February 26th. I'm going to go through some technicalities here because it is a little bit complicated and maybe non-intuitive in terms of how adult material and establishments are classified. So basically, if you, I'm going to go through the definitions just to be clear. An adult bookstore means an establishment which sells, offers for sale, or rents adult material for commercial gain. It doesn't have to just sell books, or books don't even have to be part of it. This definition includes establishments selling or renting adult videos when applicable under the above stated conditions. Now, adult entertainment establishment doesn't actually mean there's actually entertainment involved. So adult entertainment means any adult bookstore, adult booth, adult motion picture theater, or nude dancing establishment. Now, adult material means one of the following, regardless of whether or not it's new or used: books, magazines, periodicals, other printed matter, photographs, films, motion pictures, video cassettes, slides, or other visual representations, recordings, other audio matter, and novelties or devices, including but not limited to clothing, food, drinks, materials for preparing food and drinks, which have as their primary or dominant theme subject matter depicting, exhibiting, illustrating, describing, or relating to sexual conduct or specified anatomical areas as defined in the section, or instruments, novelties, devices, or paraphernalia which are designed for or used in connection with sexual conduct as defined in the section. So the exception is birth control devices or devices used for disease prevention. So the definition for adult material is pretty broad. Any business that's selling adult material that's classified as such will be considered an adult bookstore and will be considered as an adult entertainment establishment. So basically, whenever any adult material is offered for sale or rent, such establishment is classified as both an adult bookstore and an adult entertainment establishment. So it's not what you may just infer that there's some sort of entertainment involved. No, just the mere fact that you're selling anything that's classified as adult entertainment, as adult material, you are by de facto an adult entertainment establishment. So currently, such material or establishment is prohibited within 300 feet of any district designated as RS, RM, or RPS, within 300 feet of any parcel of land that's has a house of worship, school, public park, or playground, or within 1,000 feet of any parcel of land which another adult entertainment establishment is located. The only exemption currently in the code for these distance requirements is for a hotel with a minimum of 300 hotel units. This ordinance would amend the exemptions to allow the limited sale of items classified as adult material for a portion of would allow adult material in a cosmetic store with certain exemptions. So this would include a definition for a cosmetic store, which we don't currently have. So a cosmetic store would be defined as a non-medical retail business that is primarily engaged in retailing cosmetics, perfumes, toiletries, personal grooming products, hair care products, skin care products, and beauty tools. This ordinance would amend the distance separation requirements for these cosmetic stores located only in a commercial zoning district and where the adult material constitutes less than 20% of the floor area of the establishment. So this would specifically allow a cosmetic store with adult material within 300 feet of a multifamily residential district and within 300 feet of a house of worship. It would not be allowed within 1,000 feet of another adult establishment, nor within 300 feet of a residential single-family district, nor within 300 feet of a school, public playground, or park. Now, the ordinance that's drafted includes a limitation to 20% of the floor area. We're recommending that that be lowered to no more than 10% of the floor area and not to exceed a total area of 100 square feet to ensure that this would be primarily a cosmetic store and that the adult material would not constitute a large area. Well, I recommend the planning board review and transmit this to the city commission with a favorable recommendation.
Wow, that was a lot
Why?
of description.
So I honestly, I have a lot of questions.
Well, let's
Oh,
open it to the public.
fantastic.
Yeah.
Thank you.
Good morning, Board. Ian Bachakov with Ackerman Law Office, 98 Southeast 7th Street, here on behalf of EIS Inc., doing business as Geska. Geska is a German cosmetic tech company. They own hundreds of patents and put products on the market that are unlike really anything else, and the ones that are out there are extremely expensive. They mean to revolutionize the cosmetics industry with these materials that they have.
Where are they on the beach?
So they're not on the beach. They're not in the United States at all. They're seeking to put their first store in the U.S. on Miami Beach as opposed to the Design District or somewhere else, because they believe in the beach. And having met with and spoken with several commissioners, we've explained to them what we want to do, and we realized based on the existing code and how it is drafted, this is an amendment that's necessary to be able to lease a space that they would be able to use on Lincoln Road.
Where do they want to go on Lincoln?
I believe on the 500 block, so towards, I guess around the Pennsylvania Avenue area.
And how many square feet?
Their store for the retail floor area would be, I think, around 2,500 square feet, just under 3,000. It's a large space. They're going to have offices in the back because it would be a U.S. office for them as well. But the retail space, and
How big is the retail portion?
the retail portion is about 2,500 square feet. They'd be looking at maybe about 300 square feet of that is what they want to use for this particular purpose. And I'll explain that in a second so you have a better
That
idea.
seems pretty small.
Yeah, pretty small, exactly. So basically with this technology that they've produced, things that, devices you put on your face, they help tighten your skin, they give you shine, they remove the bags under your eyes. This technology that they use has been implemented in other ways as well. They've created a product line called Satisfyer, which is sexual wellness products. Essentially do the same thing, just not on the face. And yes, we laugh, but it's the highest selling product with the most reviews on Amazon. This is not something that they're selling on the side of the road trying to make more money. This is one of their biggest products, and they want to be able to sell that in their store. So it's not everything they do. 80% of their store is cosmetic products and cosmetic tech, but they do have this and they want to be able to have it in the store. And so working with the commission, with the planning staff, with the planning director, they've put forth an ordinance to amend the code that would allow us to do this, to make this work at a maximum of 20%, not to be seen from the storefront. Basically, it's hidden in the back to a limited area, and the 20% is what we need for it to work, and that's what went forward. When we saw that planning staff was recommending dropping it to 10, we were surprised because that honestly would probably undo the whole point of this whole ordinance for us. We've also met with the Lincoln Road bid. They passed a resolution in support, which if you like, I could read into the record, but they've essentially supported the 20% as well, not to be seen from the storefront.
And just to be clear, these are self-massaged female toys. They're not pornographic
Correct.
displayed.
No pornographic displays, nothing pornographic. If you don't know what it is,
Yeah.
and they'd be on, I guess, displays that children can't reach.
They're very similar to the facial devices, and
Yeah.
as far as
They
design
look identical.
Yeah.
Exactly
They are.
right.
Who's your customer? Who's your customer?
Even all of us.
Everybody.
Not me.
Everybody.
Well, do you allow minors to walk in your store?
Anybody can walk into the store. One of the things that was brought up is that if minors shouldn't be allowed in the store, we can have somebody out front checking IDs. It doesn't seem appropriate for Lincoln Road, though, but these are not things that should be visible to minors. You can't sell them to minors. That's in the code, and that's not changing. So this would be an area in the back with displays. Kids wouldn't be able to see them. They're higher up. They wouldn't be sold to
A
children.
minor can be a tall 14-year-old.
Yeah, and if they saw it, it would just look like every other facial massager in the store. There's nothing pornographic, nothing visibly pornographic about it. Yeah.
If it's a small percentage of yours, what's your unit volume?
That I don't know off the top of my head, but I'll
Because-
tell you based on the price point, their products are around $30, $40, $50, not $500, $600 like other cosmetology tech products on the market.
If it's a small percentage, how does that drive the overall unit volume, and why do you need this I mean,
Well,
why?
so, yeah, so the unit volume is probably high, so the purpose of the ordinance is to create a percentage of the floor area where these products can be displayed. It's not just one product, they have a line of them, so they want to be able to display them within the store. Again, they're not in the front of the store
But why is it necessary?
because this is a product line of theirs that they want to be able to market to everybody. It's not just the cosmetics.
Well, again, so I'm a 14-year-old with a boy with my mother, and we walk in the store. How do you market it? How would anyone know it exists? You make it sound like it's invisible. So how would the adult know and the child doesn't?
Yeah, so the best way I can put it, imagine a store that's kind of a hybrid between a Sephora and an Apple store. Very clean, smooth, sleek-looking store, displays down the center, displays on the walls, and one product in each square within the displays, and each product has labels what it is. It has a name and it says what it's for. So you would have to read next to the display what it is, and there's nothing pornographic in the language of what's being displayed there. It's describing the
If
products.
you want an example, I mean, I just.
Yeah,
looked at-
describe the
No,
product
but
then, Dave.
there's a lot of places right now that I see where I go to my esthetician. You go
Yeah.
to G Beauty in Sunset Harbor, right? And they're selling a bunch of creams and cosmetics for women. The top shelf has some self-massage, female massagers on the top shelf, and they describe this,
But it's not on
self-massagers. But it
Lincoln
doesn't look
Road.
like anything crude or anything. It's just part of products that they're
I
selling.
don't understand, what's your concern? That a kid will
My concern is I don't understand what the adult portion of this product is, and is it something that minors shouldn't? I mean, it sounds like he's saying it's hidden from the minors, but it's being advertised. So I don't understand the adult nature.
So-
Since it's a public
Yes.
forum, and there's no problem with this
Yeah.
thing, tell us all in graphic terms, what is it?
Wait,
So
wait,
What does it do?
Hey,
It vibrates.
No?
I'm just, all of this is Hello Kitty. This is
Well,
all
so
Hello
those,
Kitty that's
those
marketed
are,
to
those are the
kids.
cosmetic products. Those are
They're-
not the
they're-
Satisfier products. And I will also add that these are sold in every CVS and Walgreens, including on
This
Miami
is
Beach.
all
Court.
Hello Kitty.
hold on, I just want to remind everyone, this isn't about their store, this is about an ordinance.
Yes.
Yeah.
And it's about the products, and this is the ordinance.
No, I
And
understand
all of
that.
this is marketed to kids. Hello Kitty is,
So the cosmetic technology products they do have marketing deals with lots of influencers online, with Hello Kitty, they have a brand. Again, those are the cosmetics, those are not the adult materials as they'd be defined by the city, which is the Satisfier line, which is completely separate from that and what's marketed to kids, which, kids would walk in, those displays are lower, they would be able to see those. And again, they walk down the store, even if they were tall enough to see the adult materials, they wouldn't know what they were. They could read them, they could see adult sexual wellness products. They'd have to turn around and ask their mother, what is this?
Yeah,
It's
so
not
let me,
clear-
my concern is, let's take it away from him. If MAC or any cosmetic store decides that they want to start selling vibrators and other types of sexual material, is there anything prohibiting them under this ordinance? Why, I don't understand that he has a very specific product, but we're saying adult material, so pornographic movies could be in the back of a cosmetic store under this ordinance, correct? If
Yeah, we're not-
if it conform to 20% or 10%?
Yeah, we're not reviewing the exact nature of the adult material.
Yeah, so it opens it up.
how do you enforce this with code? How do you monitor this? I mean, it's like, how does
Well,
that work?
It does require, as Ian mentioned, it does require that they cannot display the material in such a manner that it's visible to minors, and you cannot knowingly sell or rent it to minors.
But how do you enforce that with code? We can hardly
Well,
enforce it.
code
I
can walk
think-
in there and see if that's accurate.
Well,
One,
if we-
right,
if
and
it-
one
if
way,
it's now-
Elizabeth, that could be enforced is like, for instance, when you go to a newsstand or bookstore and there are certain magazines that are on the top shelf behind a, you know, like an opaque cover, it would probably be something along those lines as far as to
Or
enforce.
buying alcohol
that
at
it's not-
at the store, or buying cigarettes, there's
Right.
age requirements to be able to buy the
Just, I mean,
material.
we're not a proactive code enforcement.
No.
We're not in the proactive business here. We're in the reactive business. And
What, we're scared that a 16-year-old is gonna go buy a vibrator and
no,
ruin
we're
her
scared of a
life?
5-year-old
The what?
that is
But-
going to
but
walk in
you
there
won't know what it
with
is
Hello
anyways.
Kitty. Everything is Hello Kitty. Look, I'm going to just.
I would also add, you know, we're not otherwise changing the code as to adult bookstores, which is what they call them. They're
Yeah.
allowed by right in the city if they meet distance separation requirements, which is, I believe, 300 feet from.
1,000 feet from another one.
1,000, yeah. Yeah, and so this is just to reduce the distance requirements for a cosmetic store selling less than 20%, so that the location on Lincoln Road would work. And there are other locations on the other side of Lincoln Road which would be allowed by right without this ordinance, which is another reason why this is kind of a specific to us request.
You didn't explain to me. Is this a adult cosmetic that goes someplace other than your face? Is this cosmetics, or is it a device that in any other place would be considered adult?
It's cosmetic technology devices that are meant for all ages. There's just this one specific Satisfier branded product line, which is what the city deems adult materials, which we would not be able to sell.
Can't we
because-
classify it as adult cosmetic and limit it more so that it's just not wide open to any kind of adult
Just for,
material?
just for clarifying this beauty line, which my
you
husband, my
understand.
husband's background is in beauty, so.
Yeah, see, I don't
So I'm
understand.
familiar with this company, and so
Yeah.
it is an actual cosmetic,
Yeah.
line of products and serums and creams and devices and facials and
Let her
technology.
finish.
So why
Let her
can't we
finish. Let her
define it as
finish.
such?
Let her finish.
So this is not some weird sort of, face front to be selling,
Right.
pornographic stuff. This is a legit company that I'm familiar with from Germany who sells cosmetics, serums, creams, devices that, for peeling and stuff.
Yeah.
And they cater to a more affordable price point, but with what they call, technology, scientific-based products. So it's a cosmetic company. It's no different than would be, I'm trying to think of a specific company that sells one brand of products. But they have their own brand they carry. And what I'm understanding, there's a certain section of it based on the technology they develop with some of the handheld devices for the facial application of the serums and the treatments and all, that they've also used that technology to develop self-massage toys for female, and so that are tasteful in the way they're just that they're designed, and they don't look like anything that is suggestive, and then they're just trying to open up a space in their retail that would be selling those products based on their and correct me if I'm
Yeah,
wrong.
you're
so far.
absolutely right.
Okay?
Thank you very much for that.
All right,
yes.
so
So is there any way then to narrow down this very wide adult definition to something that fits
yeah, I mean, I
what they're
wouldn't, I
doing?
wouldn't be
I would
comfortable
be
if they were
comfortable
selling,
with that.
stuff with porn magazines or
Yeah,
with,
I mean,
or
if
just photo-
it's a
Right,
cosmetic-
these look exactly like they would be as for there's nothing offensive. Like I
Yeah.
said, you go to G Beauty, they sell them on their shelf there.
Can you
You go
take-
to any.
Can you modify that down? Can you?
Can
take
we
it-
modify and eliminate the adult part?
Right.
So I guess, I guess the hesitation here is that the adult definition, it may include material that they would be uncomfortable. I think we're not
Yeah,
debating,
too broad.
any of the
Yeah.
self-massage tools. I think they're more
Of
worried if
course.
it goes into a whole different
Exactly.
category.
Yes.
We would be okay excluding, videos, magazines. I mean, we're specifically looking to sell this product line and
So-
no other adult materials.
And
It just
reduce
this-
it 10%.
Well, we
why
are
are we doing
specifically
20 for-
requesting at least
That's
20%.
what the city's
But why are we
recommending.
recommending 20 to 10 at that point if you're putting a separate section? Like how important is it to go from 20 to 10?
20% seems pretty large in terms of the overall area.
Especially when it's only 300 square feet.
Well, it
That's
would be,
huge. Yeah, but-
even at 10%, they say 10% or not to exceed 100 square
Like I
feet. So
said-
that's our concern. We would like more than 100
We did
square
not, I
feet
did
of
not
store.
work with Ian. Nobody gave me a floor plan. This was referred from the city commission. We didn't have the direction to include the specific address, so we didn't have this information. So we gave our best guess in terms of what we thought would be appropriate.
I mean, I think the, going from 20 to 10 is kind of a we're
Or-
counting, but you can always go.
Or if they're okay with the 10% as long as you take out the 100 square feet. Is that a problem?
It's up to the board in terms of
Is
recommendation.
that what I'm hearing? You don't mind the 10%, but it's the or?
We would request to leave it exactly how it was drafted at the 20%. If we reduce it down, we'll obviously try and work with it, but it creates a hardship for us based on the designs we've already created.
Well, hold on, can we get back to this? So let's get back to the original question. Is there a way to, so I don't think people are gonna have a problem with 20% if we can eliminate some of the categories of adult material. Is that possible?
Or,
Yes.
or in the inverse, if we specify, like personal massagers, for example, that you know, rather than try to exclude every category,
Define what they sell, yeah.
and maybe that there's a basis to treat that differently than
Yeah.
other.
I would just remind the board, this is a text amendment brought by the city. It's not an application for us for
Right,
commercial
it's
use
my-
permit.
But it
tried
came
to
from
point
you,
that
but
out.
it came from
So
you for
putting
this store.
the name
Ian.
of our product right into the
It
code, we're
came from
fine
you.
with that.
It came from you for this store, otherwise it wouldn't be here today.
No,
So
that
it did come from you.
that's absolutely right, but technically, we're not the applicant. It's the assistant city
And the
manager.
city's
saying-
waiving the fees for this. The direction is for the city to waive the application fees.
We would not
for
be
this
here
item.
if the city. and
Right,
the
so to
commission
make it
didn't
palatable
want this
to the-
store on Miami Beach.
We don't know what the percentage of sales from these items come from. We don't know the,
I don't know that's really the issue. It's about
Right.
what's displayed in the store and the
well,
percentage
it's
of the
kind of
store.
an issue. What are your what are your sales volume that come from these?
That I don't know, because right now we don't have any stores in the US to get that metric. This is an international company.
How
Their
many
stores are
stores
in
do you want to
Europe.
open in Miami Beach?
Just the one, but looking to do hundreds throughout the US. This would be the first one. This is.
So Nick, again, getting back to the germane issue, it sounds like what the concern is the definition of the adult product. So can you come up with a suggested recommendation about how to alleviate that concern?
Yes, and I would want to be very careful about that because I don't want us to get in the business of determining what is adult or what isn't, or
Right.
distinguishing even between types of adult material. But I think I understand this is a text amendment, but I think the question here is about a very specific type of material that is sold generally in retail stores like drugstores. So I think, based on the discussion, I think there is a basis to treat something like, for instance, a personal massager differently
Correct.
from other types of adult material, and that maybe the provisions here in, let's see, 7.5.5.2 could only apply if, if it's a cosmetic store seeking to sell personal massagers.
Personal, yeah.
Yeah.
Just make it that
I'd be
narrow.
fine with that.
And subject to all the other restrictions that we've drafted, the square footage,
Because the line
whatever the
doesn't
board.
include anything else, right? It's
that's
all
That's all you're
okay.
doing, okay.
Okay, well,
And
then,
let's
if
limit.
we can do that, I'm fine with 20%.
And you're good with that?
We're good with that. Thank you.
Yeah.
All right, I'll make a motion for that. Anyone have any other comments?
So hold on, do we have to make a motion to approve favorably and then do a second motion with the recommendation, or can we do it?
We
in
could do
one?
it all together.
Okay, all right, go ahead, Melissa.
I want to make sure I want to make sure.
Right.
Okay,
So correct me with the wording here. So motion to approve with including that the adult toy be limited to personal massagers.
And are we taking out bookstore and all of that kind of stuff?
Well-
No, that's.
No, that covers it.
So this is, if, on page 176 of your book, this would be an amendment to paragraph 4.
Sorry, which page, Nick?
176 of the book.
Right, paragraph 4.
And it would
that's
be an
underlined.
amendment to paragraph 4 where it says, a cosmetic store located in a commercial zoning district and where adult material, that's where we would insert,
Correct.
consisting of,
Personal massagers.
personal massages. And then I think in the recitals, and this is something that we will do internally, but in the recitals for the ordinance, I think we can explain there that this particular product is something that is, it's not limited to just standalone adult stores, but rather is generally sold, has neutral marketing materials, and so long as it's, not visible from the storefront or to minors, there is it is different from other types of adult material that is regulated. I think that's how we could handle this.
All right. Good. All right, so I need someone to second that?
All right. Can we get a second?
I'll second that.
Okay. All in favor? Aye. Anyone opposed? Okay.
Thank you very much. Can I just add, I'd be remiss if I didn't just congratulate the Florida Gators on their national championship yesterday.
As painful as it is for me, congratulations.
Thank you.
Smart not doing it before you presented.
By the way, that was over 20%.
Yeah, 20%, right? We got this at 20%.
That was at 20%, not the
20%, that's right. Mr. Chairman, if I may, I wanted to respond to the question on the
Sure. On the
commercial.
parties.
Yes.
Yeah. Melissa, this is for you.
I'm sorry, I just wanted to respond to the earlier question on the commercial use of single-family homes.
Yes.
So it is two ordinances. The ordinance that the board transmitted today governs commercial use of single-family homes in the land development regulations. What that ordinance does is prohibits the sponsorship of an event in a single-family home by a for-profit entity and prohibits the promotion of any event, whether or not sponsored, via social media platforms. The separate amendment that was approved by the City Commission is an amendment to the special events regulations. And what that does is for those special events that are permitted, meaning
Charitable.
non-commercial,
Not advertised,
right,
right.
exactly, that if the event meets certain indicia, that a special event permit will be required. If fireworks are involved, if more than, and this was your question, if more than 100 attendees may reasonably be expected to attend, when more than 50 vehicles are expected to pick up or drop off passengers, where institutional or commercial grade speakers, lighting, generators, or other equipment are expected to be utilized, or where an institutional or commercial grade bar that meets certain staffing requirements is expected to be used. In that case, a special event permit is required. So it's a two-pronged approach, but the minimum number of people in the other ordinance is 100.
Okay, thank you, Nick.
All right, meeting adjourned, and I know you all have lunch coming at noon if you want to wait around for it. But that was a record
Yeah.
as far as,
All right, who knew?
Great stuff.
Who knew was the Adler category going to keep us talking the most this morning?
so funny.
I should have asked him if he brought one and he could show it to everybody.
Maybe we should have.